The content of the following program, including all statements from the host and guests, is to provide general information and commentary about the law. Under no circumstances does any statement made by a host or guest to a caller or listener constitute legal advice or the formation of an attorney-client relationship, and the material from this program should not be viewed as a substitute for personal consultation with an attorney. Welcome to Talk Legal with Jeff Van Treese, who brings you all the latest news in the legal world. Jeff will be discussing a variety of legal topics with experts in the field. If you would like to ask a question or share a story on the air, please call toll-free 888-565-1470. Once again, that's 888-565-1470. Now, let's talk legal with Jeff Van Treese.
Good evening and welcome to another edition of Talk Legal. I'm your host, Jeff Van Treese. I'm an attorney with the law firm Oltman, Flynn & Kubler, where we practice intellectual property law, including patents, trademarks, and copyrights. I'd like to thank all of our listeners, both those of you tuning in on the AM dial as well as those watching online. If you have a question, comment, or story that you'd like to share on the air, please feel free to call us toll-free at 888-565-1470. We welcome your calls. My guest this evening is attorney Warren Redlich. Warren is the inventor of the DUI flyer right here. This has gotten a lot of attention in the press. He's been on this show. He's discussed it a number of times. In fact, we hosted a debate with a former prosecutor on this show back in February. Warren also is the creator and editor of the online news periodical, westbocanews.com, so you can check that out as well. And this evening, we're going to be discussing some developments that have taken place with the flyer. So, Warren, thank you so much for joining us this evening.
Oh, thank you so much for having me on. It's a pleasure.
So, this flyer's gotten a lot of attention. If you want to just give a quick summary of what it is.
Sure. When you get stopped in a traffic stop or in a checkpoint, police approach the window. What people typically do is they roll down their window without being asked to. They start talking to the police officer voluntarily, and that is usually two of the things that lead to you being arrested for DUI, even when you're innocent. And this is designed to protect innocent people from wrongful DUI arrests. So the first thing is you don't roll down your window until you're ordered to roll down your window, and we'll talk about that in a minute, the difference between an order and a request. And you hold up this flyer, and you hold up your driver's license if you're asked to show your driver's license. And it says, I remain silent, which is your Fifth Amendment right to remain silent. It says, no searches, which is your Fourth Amendment right to be free from unreasonable search and seizure. It says, I want my lawyer, not I want a lawyer, but I want my lawyer. You don't have a right to a public defender at that point, but you do have a right to talk to your own attorney at that point. And then there's some instructions to the police officer to help him figure out what he's supposed to do, because a lot of police officers are not familiar with this. They may not know what to do, and these instructions refer to Florida law and help them make a good decision rather than a bad one.
And, of course, one of the most important things on here is the very bottom line, which is, I will comply with clearly stated lawful orders. A lot of your critics have said that the police might think that you're not cooperating or refusing to cooperate, but it says here that you will comply with any order that's given to you. And, of course,
and when
important.
I talk to people, one of the issues that people have a problem with is, well, how do you know if the order is lawful? So my general advice to people is, if you're not sure if the order is lawful, then you should probably obey it anyway. And the point is that your attorney, when you're prosecuted, your attorney can now raise the issue, was that order lawful or unlawful? If the order was unlawful, then your attorney can then go to the judge and say, hey, that order was unlawful, therefore you have to throw the evidence out that followed from that unlawful order.
And, of course, if you consent, then that takes that argument away completely, and you haven't preserved that argument. Only when you assert a right can you actually come back and have the evidence excluded if the right was violated. If you give up the right and you waive the right, then you have no ability to do that.
It's one of the things that frustrates criminal defense lawyers more than anything else. Is not more than anything. There's plenty of things that frustrate us, but our clients talk too much. What we want our clients to do is shut up. We don't say it that politely. We insert colorful language when we tell them to shut up. We don't want our clients to talk to police at all. And when people roll down the window, they have voluntarily waived their Fourth Amendment right not to have the police smell inside their car, look inside their car, whatever it is they're going to do inside the car. When you speak to police, you have voluntarily waived your right to remain silent. You have that right. This card allows you to assert it. And by the way, one of the reasons for the flyer is, there's a court case not too long ago where the Supreme Court said you had to affirmatively assert or explicitly invoke your right to remain silent. Well, so you have to say I'm remaining silent. You have to be not silent in order to remain silent, and that's a catch-22. And I thought, well, if you put it on a flyer, in a piece of paper, and you hold it up, now you've asserted your right to remain silent while remaining silent. It's kind of like Kramer's coffee table book that's also a coffee table. It's just I'm trying to kill two birds with one stone or something, or I'm trying to avert a catch-22. And so I find that that's effective at communicating to police, and it has been working for us in checkpoints.
Now, if we might just go through the flyer here, it says, please put any tickets under the windshield wiper. That sort of gets to the question of whether you have to sign the ticket. So do you have to sign, or how do you get out of signing?
Sure. So generally in Florida, you do not have to sign tickets. There are certain exceptions. If it's a criminal charge, in other words, if it's a simple speeding ticket for 15 miles an hour over the limit, you do not have to sign. If it's you ran a red light, you don't have to sign. But if it's more than 30 miles an hour over the limit, that's one of the exceptions. It's actually on the back of the flyer. If it's more than 30 miles an hour over the limit, if you passed a stopped school bus, improper load, a criminal violation, or where there has been a death or serious injury, there are exceptions. And if the police officer says, sir, I'm ordering you, you have to sign this ticket, well, then, again, you've been given an order, roll down the window and sign the ticket. But in general, in Florida, no, you're not required to sign tickets. Now, in other states, you might be.
Are you required to talk to the police? Because there's this case from the 4th District Court of Appeal right here in Palm Beach that would appear to say that you don't have the right to remain silent at a sobriety checkpoint, that you do have to speak to the police. So this can get somewhat problematic.
Sure. So that's a checkpoint case, I believe. So it's an interesting problem, and it's one of the things that we're heading towards. We're heading towards litigation. We're going to be filing a lawsuit in federal court over this issue. Rinaldo versus State is a case that basically says you don't have any rights in a checkpoint. You have more rights if you're suspected of murder than you have if you're suspected of nothing. And I think that's a paradox. That's something that doesn't make sense, and I think the federal courts need to address that. So, do you have a right to remain silent? When I was debating the statewide traffic prosecutor on Newsmax TV, I called him on it. I said, are you saying we don't have the right to remain silent on a checkpoint? He says, no, you have the right to remain silent on a checkpoint, but you still have to roll down your window. And there's this question, well, why do I have to roll down my window? And one of the reasons we decided to have this interview today is because, or what we wanted to talk about today was that prosecutor issued a memorandum that was sent out to various police agencies, or I'm not sure who it went to, but I actually got a copy of it. I'm not sure if I was supposed to get a copy of it, but I ended up getting a copy of it. And he says that you do have to. There's a question that a big question that came up is, when the police pull you over, or when you're in a checkpoint, do you have to physically hand your driver's license to the police, as opposed to what I've been recommending, which is you press it up against the window and hold it there so that the police can see it, but they don't physically hold it in their hands. And there's a statute, Florida statute 322.15, that says, it used to say you were supposed to display your license to the police. One part of the statute was changed to the phrase present or submit from display. Well, what does that mean, present or submit, and why is it different than display? And Mr. Berman and some other prosecutors have taken that to mean, well, now you're required to physically hand it over. But they don't define present or submit in the statute, and we all know that you can present something without physically handing it to someone. There's presentation software. You do a software where you're making a show to people. What is the thing where you do slides? PowerPoint. PowerPoint is a presentation. Well, you don't hand the PowerPoint to somebody. You make the presentation.
Well, it's interesting because I read the memo. The memo said that this would probably only be decided through litigation. In other words,
he knows it's coming.
He knows it's coming, and he's just taking a position that would further the argument for the checkpoints. Yeah. But he has no support. There's no case law from courts. And there's nothing in the statute, like you said, there's no definition of those words.
Right. To be fair to him, I think he's a genuine guy. I don't always feel that way about prosecutors. But I met him, I've talked to him, he wrote a thorough memorandum. I don't agree with his conclusions, but I don't think he's making it up, or I think he believes in his cause. And so he's looking for the answers he wants. I think he's misguided to some extent. And the key is with this particular statute, I don't know if you guys have that you can put it up on the screen, but the statute is 322.15 of the Florida statutes, and there's 4 subsections. And subsection 1 is the one they're relying on, and that says present or submit. That's what was changed from display. The reason it was changed was because people are starting to get documents on cell phones. I think particularly now it's insurance. Sometimes your insurance will give you your insurance information. You know, that card that you carry around the car. They're starting to give that so people can have it in an app on their phone and you don't have to carry around the physical piece of paper. And they're anticipating that's going to happen with driver's licenses, registrations. It hasn't happened with driver's licenses yet, but in anticipation of that, they modified the statute for that reason. They didn't modify it because there was a problem with physical driver's licenses. And so that's subsection 1. What's interesting is there's 4 subsections, and there's also the title of the statute. And the title of the statute always read you're required to exhibit your license. You're supposed to exhibit your license on demand is the way it's phrased. They didn't change that. Subsection 2 says if you fail to display your license, then the police officer can do this. Well, it says display. They didn't change subsection 2. And the best part is subsection 4, which says failure to display as required in subsection 1 is a non-criminal, non-moving traffic infraction. It's not even as bad as a speeding ticket. So Mr. Berman didn't look at the title, and he ignored the fact that subsection 2 says display, and he ignored subsection 4 and didn't really talk about it in any of his analysis. The city of Coral Gables, how I stumbled across Mr. Berman's memo was that the city of Coral Gables did a memo to their police, and actually had an outside attorney do a memo to their police advising them how to deal with the situation. And they actually recommended if somebody doesn't physically hand over their license, to arrest them for resisting without violence, which is a crime. But the statute itself says if you don't comply, it's a non-criminal traffic infraction, non-moving traffic infraction. So how can you turn something the statute says is a non-criminal, non-moving traffic infraction to a criminal charge? You can't. That's nonsense.
It also gets back, to what I was saying.
The short answer is if somebody does this and you're a cop and you want to protect yourself from being sued by guys like me, then when somebody refuses to hand over their license but they show it to you through the window, write them a ticket. That's all you do. You write them a ticket for violating section 322.15 and stick it under their windshield wiper and let the courts handle it. Don't get yourself sued over this.
And of course, it goes back to saying you will comply with all lawful orders. So you're not refusing to do anything. If the officer orders you to do something, you're saying you'll do it. It's
right.
Just that you're not going to do it without being asked.
No, and this comes to a really interesting question I've gotten from a lot of people on YouTube videos, on our Facebook page. Our Facebook page is Fair DUI as well, and YouTube video is W. Redlick. YouTube channel is W. Redlick. But people are confused about what's an order.
This is an important point. Yes.
And I never thought about that when I started this. To me, it was obvious, but it turns out it's not as obvious as you think. And I think people actually are pretty smart to ask this question. So if a police officer comes up to your car and you haven't rolled down your window, and the guy says, "Sir, would you please roll down your window?" That's not an order. "Sir, would you please roll down your window?" That's a request. And if you roll down your window, you have voluntarily rolled down your window and you've waived your Fourth Amendment rights. If he says, "Sir, would you mind rolling down your window?" "Oh, yeah, I would mind." You don't roll down your window. It's still not an order. If he says, "Roll down the window, I'm going to smash it in," that sounds a lot more like an order. But there is a potential gray area there. What's an order? What's not an order? And one of the dangerous things you run into is that you can have a cop say, "Sir, would you roll down your window, please?" And you don't roll down your window because, of course, it hasn't been stated as an order yet. And you get charged with resisting an order without violence when it wasn't an order. And then you get in front of a judge, and you got to hope that the judge understands the difference between a request and an order, and that the prosecutor understands the difference between it, because the police officer obviously didn't understand the difference between a request and an order. And the goal that I want my clients to do is to be patient, and basically to outweight the police officer. The biggest problem that people have in traffic stops and police encounters in general is they're impatient. They want to get out of there. And the police use that. Listen, if you just tell me what happened, you'll be able to go. It's a lie. Of course, as soon as you tell them what happened, you're going to be charged, and they're going to use what you said against you. But we don't want our clients talking to police. And the game, essentially, unfortunately, it's a game, is to wait out the police officer and wait until he makes it a clear order. Wait until it's obvious that it's not voluntary. And now I, as your defense lawyer, can use that non-voluntary situation for a motion to suppress the evidence, for a motion to challenge what the police did, and possibly for a lawsuit against the police for violating your rights by giving you an unlawful order.
And like you said, it's very likely that there's going to be some ambiguous language that the officer might give you that you can't quite understand if it's an order. And this also gets back to why it's important to film what's going on. If you don't have this on tape, it's going to be very hard to prove that it wasn't an order.
Yeah, and actually what I do, I have this in my car all the time, right by my left knee in the pocket of my driver's door. I have my documents in a paper clip in the glove compartment ready to grab, and I keep my phone. I do this anyway. I keep my phone in the cup holder, and it's like 2 steps for me to get my phone on and recording. Maybe 3 steps. It's fairly quick for me to get my phone on recording. So set my phone on record, put it in the cup holder, and bang. By the time the police, if I got pulled over, which fortunately doesn't happen a lot. I tend to be a fairly safe and calm driver these days. When I was younger, I wasn't so good, but I've straightened out. But if I get pulled over, I'm ready, and I'm ready instantly. And when the police officer, and so you want to set yourself up. If you're planning on using this flyer, you want to be ready to record the encounter. Frankly, I think you want to record the encounter even if you're not going to use the flyer, because the recording the police officer may be making, if they're making one, is coming from a dash cam, and it may not pick up what's happening at the window. So it's not going to see whether you held up a flyer or not, for example. It's not going to see whether you rolled down your window or not.
One of the things that's sort of in the backdrop of this issue is whether is the public's trust in law enforcement, and whether if a police officer that you've never met before pulls you over, do you trust them to comply with what they're required to do and to follow the Constitution? You recently wrote about a story in your news periodical with a DUI manslaughter case. There was an acquittal of a defendant by the name of Joanne Liu. And
West Boca case.
It was a West Boca case. This raised some very interesting issues and was actually quite troubling if you look at this prosecution.
Yeah, well, so Joanne Liu it was a fatal accident, and it's probably Joanne Liu's fault. I don't think it was definitely established in the trial that it was her fault, but most people looking at it think it was probably her fault. But being at fault in an accident where someone's killed is not a crime. If you did something wrong that caused the accident, something criminal, if you were driving recklessly, if you were impaired by drugs, if you were impaired by alcohol, if you were racing, certain things can get you to the point where you're criminally responsible. But if it's not criminally responsible, you're still civilly responsible. You still can be sued, all those things.
Driving over the speed limit and hitting someone is not a crime.
It's not a crime. It's a traffic violation. Yeah, you have to do a lot more to rise to reckless driving than that. And running a red light is not a crime. So you can run a red light. The circumstances that lead up to it could potentially make it a crime, but it's very hard to get over that hurdle. So anyway, Joanne Liu, they arrested her and charged her with driving while impaired by drugs. And the problem was that when they did the blood draw, it showed, this is a technical scientific thing, but it showed metabolites of cocaine. What metabolites of cocaine means is it showed that she had used cocaine at some time in the past, but long enough ago that she had no active cocaine in her system. It's not clear how long. I don't think from the evidence it was clear how. Could have been 2 days earlier, could have been 6 hours earlier, but whatever. The active effect of the cocaine in her system was gone. So they really had no proof that she was impaired by drugs, and they actually argued that she was impaired, that she was coming down from the high, and that somehow she was impaired from that. So she was impaired by the absence of drugs.
This is where you don't know whether to laugh or cry when you hear something like that.
Well, I mean, look, you feel bad for the family that lost their family members in the accident, and I personally feel bad for Joanne Liu that she's going through a case where she's being prosecuted wrongly. She should not have been prosecuted. Once they had the blood test result, they knew they didn't have a case. And to argue, I mean, this is one of the things that defense lawyers get upset about, is when prosecutors come up with creative theories to continue prosecuting somebody that shouldn't be prosecuted. I know this is controversial, but George Zimmerman should not have been prosecuted. It was a creative set of theories that led to the prosecution. And the cops didn't want to prosecute him. They knew he was innocent. The jury knew he was innocent. Whether you're happy with what he did is another question, but he didn't commit a crime. And the same thing with Joanne Liu. Yes, there was an accident. Yes, someone was killed. But did she commit a crime? And for the prosecutor to come up with this novel theory that she was coming down and that she was essentially impaired by the absence of drugs, that's like saying an alcoholic, as I wrote in my article, that's like somebody who's an alcoholic and hasn't had a drink is impaired by the cravings. They're craving alcohol and their behavior, or a heroin addict who hasn't had heroin. And if you've ever seen Train Spotting, they behave very awkwardly when they don't have their heroin because they're trying to get heroin. And the statute is not driving while impaired by the absence of drugs. It's driving while impaired by drugs. And there's a whole long conversation about whether cocaine even impairs driving. I don't even want to get into that. But in this case, it's very clear she had no active cocaine in her system. There was no valid prosecution. She should not have been prosecuted. They were wrong.
It really shouldn't have even gone to the jury, which was...
It shouldn't have been prosecuted. It shouldn't have gone... it shouldn't have... It was an absurd case. It should not have been done.
And in that case, it also involved a situation where the medical examiner testified that the victims of the accident who died, who were not wearing a seatbelt, would have died even if they were wearing a seatbelt, which is quite an outrageous claim.
This is actually something that really chaps me, and it's not just in the context of this case, but in DUI cases in general. But I've seen a lot of cases where someone's killed in an accident, and it's almost always that they weren't wearing their seatbelt. And the texting while driving thing, there was some video on Oprah about somebody who died. Somebody died, texting while driving, whatever. And the evidence, the last text message was 6 minutes before the accident. And the person was ejected from the vehicle. Whenever you see an accident where someone's ejected from the vehicle, they weren't wearing their seatbelt. And yes, I find it and the guy who made that claim that they would have been killed even if they had been wearing their seatbelts, he's not qualified.
He's not an engineer.
He's not a biomechanical engineer. I forget what his profession was, but he's not scientific.
I think it was the medical examiner, but he was not qualified to testify about what would happen being ejected from a vehicle.
I think he's a politician. He's not a scientist. He's not an engineer. He's not qualified to make that judgment. To make that judgment, you have to have more training than that. And, as an attorney who handles civil cases, personal injury cases, if I want to advance that theory in a personal injury case, I've got to have, solid scientific, expert witness testimony. And unfortunately, what people don't realize is in criminal courts, you get, the person who does the breath test has a high school diploma and 24 hours of training. That's 3 days. That's the level of training that's required to operate a machine that proves you're innocent or guilty. And people actually buy that this person's qualified. They're not qualified. They're not scientists. They don't have college degrees. They don't have associate's degrees. They may not have any college coursework at all. And we're letting this person operate a supposedly highly reliable scientific instrument. It's absurd. And this is one of the things that permeates our criminal injustice system. People call it the criminal justice system. I call it the criminal injustice system. And look, there are very serious crimes and people who need to be prosecuted and put away. And prosecuting cases like Joanne Liu and George Zimmerman that shouldn't be prosecuted takes resources away from the real criminals who really should be prosecuted. And that's a judgment call that I think is made wrong a lot by our county prosecutors.
Since you brought up George Zimmerman, I think there's an interesting lesson to be learned from that case. Whatever you think about the outcome of the case, the merits of the case, etc., one of the things that everyone can agree on is that he did convince the police when he spoke to them, when he waived his right to remain silent, he did convince the police that either that he was innocent, that he acted in self-defense, or at the very least they couldn't disprove it. So he talked to the police and could not have had a better outcome with them. He convinced them that he was innocent, and he was still tried. So that really highlights the importance of remaining silent, because even
his statements were used against him by the prosecutor.
His statements were used against him by the prosecutor. So the police, the ones that you're talking to, they're not even the ones that make the call about whether you're going to be charged necessarily.
Zimmerman's case is an unusual case. I think if it had not been for the national publicity that came to the case, it wouldn't have been prosecuted. It was prosecuted not because a prosecutor looked at this case and said, we've got to prosecute it. It was prosecuted because there's all this national attention. The Jameis Winston case, I also think should not have been prosecuted. The prosecutor made a good decision, but could you imagine being the prosecutor in Tallahassee who prosecuted the star quarterback at FSU? There's no way. I mean, I wouldn't be surprised if that was playing in the back of his mind, at least, as if I prosecute this guy, I'm not going to be able to eat out in Tallahassee for the rest of my life. I'm going to have to move.
But at the very, even if you disagree with the verdict, you could not. You would have to acknowledge that almost nothing good can come from talking to the police.
I do think in his case, had it not been the national publicity, talking to the police may have helped him. It might have helped him in that case, but in general, it's not wise. And if you follow firearms safety and training and how to deal with these kind of situations, the general theory is you want to say as little as possible, and you basically say, look, there was a shooting. Maybe you say he attacked me. You say something very brief and say, but I hope you guys can understand. I can't talk anymore without speaking to my lawyer first, which is exactly what the police are trained to do.
Right.
If there's a shooting.
Now, you've appeared on a number of shows. You're on Fox and Friends. I thought they gave you way too little airtime. I would have liked to have seen more on that. But Dr. Drew talked to you at quite some length when you were on his radio show, and I thought it was interesting. There was he had a co-host. I don't recall his name, but he said something to you along the lines of, the sobriety checkpoints, they just keep us safer they keep drunk drivers off the road, and if innocent people get arrested, then they're just collateral damage. And you responded by saying that, well, if that's the way you think, then you should move to a different country, because in the United States, the priority is always on keeping innocent people out of jail.
So, there's an underlying, I read most of my feedback. Believe it or not, most of my feedback has been positive. I do get some negative feedback, and the negative feedback often relies on a misconception. And the misconception essentially is that the police don't arrest innocent people. They just ultimately believe that either the police don't arrest innocent people, or if they do arrest innocent people, it just gets magically corrected right away with no cost to the person who's arrested. And that's not true. I've seen people who are innocent plead guilty because they can't handle the pressure. People get arrested and they hire an attorney who doesn't know what they're doing. I've represented people who've had another attorney who was telling them to plead guilty. DUI case, not DUI case, whatever. I've represented innocent people who've had their paid defense attorney tell them to plead guilty to something that I ultimately got them acquitted on. I had one case that stands out in my mind where a guy's accused of stealing from the store where he worked. And, his lawyer was telling him to plead guilty, and we went to trial, and they dropped it at trial. They didn't even bother questioning jurors. They just gave up because they knew they didn't have a case. Innocent people get arrested. Innocent people get prosecuted. Innocent people get convicted. And that matters. And, you think it doesn't matter until it's you or your child. And I have them they come to me. Why is my child being treated this way? Well, do you vote for politicians who say we got to be tough on crime? Yeah, well, then your child's being treated this way because you told them to. Yeah. But I didn't mean my child. No, you meant those other people. And there's this other thing that goes on in the backs of the minds of people. I had a client who was arrested and he was in jail. He says, "You got to get me out of here. I don't belong with these people." As if these people belong here. And some of them do, but not everyone who's in jail belongs there, and not everyone who's arrested should be arrested. And people think it's an anomaly when I get arrested and I'm innocent, and all those other people are guilty. The reality is a lot of innocent people get arrested.
It's when you divide people into us and them, and then that line becomes blurred when you're on the other side of it. We have about a minute left. I just want to give you an opportunity to give out your contact information.
Sure. I mean, the biggest thing is our website is fairdui.org, FAIRDUI.org. You can reach me. West Boca News is my other passion, and I'm Warren at westbocanews.com if people want to email me. And the phone number's on the back of the flyer. It's 888-RED-LAW. 888-RED-LAWYER.
Excellent. I'd like to give another very special thanks to my guest, Warren Redlich. This is Jeff Van Treese for Talk Legal. Please tune in next week, Tuesday night from 6 to 6:30. Thank you so much, and have a great night.
Thank you for listening to Talk Legal with Jeff Van Treese. Tune in next week for more insightful and exciting information about the law. You can contact Jeff by email at jvt2law@gmail.com or give him a call at 561-789-6866. That's 561-789-6866. The content of the preceding program, including all statements from the host and guests, is to provide general information and commentary about the law. Under no circumstances does any statement made by a host or guest to a caller or listener constitute legal advice or the formation of an attorney-client relationship, and the material of this program should not be viewed as a substitute for personal consultation with an attorney. The opinions expressed on the preceding sponsored program were strictly those of its hosts, guests, and callers, and not